All right, good afternoon, Corporations Committee. We have 1 hour to potentially get through 3 pieces of legislation today. We'll see how far we get. Barb, if you'd call the roll.
Representative Blackburn. Representative Burt.
Here.
Representative Clausen. Representative Duncan.
Here.
Representative Ayer.
Here.
Representative LeBeau. Representative McGuire.
Here.
Representative Roscoe. Chairman Swanitzer.
Here.
Thank
So,
you.
First up today, we have Senate File 27, which was actually a joint judiciary interim committee bill. But I believe maybe the speaker was here last week and we talked about a similar bill. I'm not exactly sure why I got a joint judiciary interim committee bill, but similar to some of the discussions we had last week about allowing county commissioners to dissolve certain specified boards. This again follows that same line and direction. And so the speaker apparently seems fit to send it our way. But maybe we could ask the County Commissioners Association to give us some background in the bill, and then any changes in the Senate. I think I'm the only person on this committee that's also on judiciary. So Mr. Riemann, are you presenting? Yep, go ahead.
Good afternoon, Mr. Chairman, members of the committee. I'm Jeremiah Riemann here on behalf of the Wyoming County Commissioners Association. Joining me on my left, your right, is Commissioner Lee Livingston from Park County, and on my right, Commissioner Gunnar Malm from here in Laramie County. Mr. Chairman, what I thought I'd do is walk the committee through the bill without any commentary around our perspective, and then come back to our public comments on it. So, Mr. Chairman, on page 1, it is new statutory provision that would give the county commissioners the power to dissolve certain boards and districts that they create. So just quickly identifying what those 3 areas are. In that first paragraph that you see on lines 13 through 16 is provision 1810-103. That deals with museums. The next line has 1811-101. That deals with solid waste disposal districts. And then if you look in that same line 15, it says, or Chapter 9, Article 1 of this title, that deals with fairgrounds, airports, parks, and recreation systems. Mr. Chairman, moving over to page 2 of the bill, if the commissioners determine that they want to proceed with dissolution of one of those entities, then not later than 120 days before the proposed dissolution, they are to develop a plan for that dissolution. That plan has to include 3 primary elements. The first one is there on lines 9 and 10, which deals with the payment of all bonded or other indebtedness of the board. The second one is the disposition of assets in accordance with some various pieces that you see at the bottom of page 2 and moving over into page 3. These provisions are largely mirror to what you would find in the special district statutes across many of our titles that we have. Mr. Chairman, moving over to page 3 is provision C at the very top of that, or actually I'm on page 4, is the third provision, C, that says commissioners as part of that plan must also consider the resolution or reassignment of all contracts, regulatory agreements, or other obligations to which the board or district is a party. I'll come back to that because that was an addition that the Senate put in, but I'll also say that some version of this was actually adopted by the Judiciary Committee during the interim. Unfortunately, it was left out and we had to bring it back in for adoption. Mr. Chairman, on page 4, lines 5 through 8 is a requirement for a public meeting. This one is to be no more or not later than 30 days before the proposed dissolution. And then the next provision provides that the commissioners, after going through all that process, may revise the plan and shall either disapprove moving forward with the dissolution or actually approve moving forward with the dissolution. The bottom of that page is relative to the final termination of the board or district. And there is a requirement that moves over to page 5 that not later than 90 days after the passage of the resolution, the dissolved board or district shall cease to exist. Mr. Chairman, moving into section 2, moving down on page 5, again, we're talking about the boards and districts that are covered by this legislation. And this is just going into Title 18 relative to commissioner powers and inserting that the commissioners have this power to dissolve subject to what I just went through. Mr. Chairman, moving over to page 6, it goes into each of these entities. The first one at the top there, 18.9.101. Again, that's the fairgrounds, airports, parks, and recreation systems. Moving down to line 14, deals with museums. And then turning the page to 7, or actually, let me back up just quickly. The Senate did add a provision at the end of the museum element, starting on line 20, that says, if the commissioners are going to dissolve a museum district, then they shall ensure for the preservation of museum artifacts and collections in cooperation with the appropriate authorities. I'll come back to that again in my testimony on why that exists there. And now, Mr. Chairman, on page 7 is 18.11.101, going into the solid waste disposal districts and adding them to this legislation and giving the commissioners the power to dissolve them. Mr. Chairman, if it's okay, I'd like to give you my testimony and then I'd be happy to take any questions.
There goes. And so committee, maybe just a little bit of extraneous information. So the Judiciary Committee, one of our interim topics was to look at recent Supreme Court cases that asked or implied that there was a problem with statute and asked the legislature to look at those statutes. And so this is one of those cases where the Supreme Court arising out of Laramie County that was contentious in my county, to be quite honest, went to the Supreme Court. Supreme Court did make a ruling in this regard and had some direction to the legislature that maybe our statutes needed to be clarified in this regard. So would that be correct, Mr. Riemann, where this came from? I don't know if anybody wants to get into the specifics of that case. Certainly a Commissioner Mom here who would love to relive that experience. But that's ultimately why this was a joint interim judiciary topic. We looked at several cases and had several issues in this regard. But this was based on a recent Supreme Court opinion. Any questions in general about the mechanics of the bill I can try to help with, or Mr. Riemann can before they go kind of through a testimony based on his organizational thought? Representative Clausen.
Thank you, Mr. Chairman. Just an example of what a trustee board, something that might fall along those lines.
Mr. Riemann, could you be a little more specific on the boards that would be affected in 9.1, Chapter 9, Article 1?
Yep, Mr. Chairman, I could really point to any of these. I'll just quickly perhaps point to the museum boards. I suspect you'll hear some testimony around that. 18.10.101 states that each Board of County Commissioners may purchase property, et cetera. And then in 18.10.103 says that the Board of County Commissioners can appoint a Board of Trustees to oversee the assets that the county has acquired. So, Mr. Chairman, I think a good example, you had your tourism improvement district bill. The county or the city or collectively, the two of them could establish those tourism improvement districts, but turn over the day-to-day management to some other group that would do that. But in all cases, at least my review of each of these areas, the Board of County Commissioners has responsibility for the assets.
Okay, seeing no Representative McGuire.
Thank you very much. Just an item for your consideration, looking at page 5. Under powers and duties generally, line number 13, where it says county commissioners has created under this article. I'm just wondering if you would like to broaden that language insofar as if maybe there's a board or something that wasn't necessarily created by the county. Maybe it was created by some other entity and sort of inherited by the county. Don't know if that would ever happen, but I would just invite you to take a look at that and see if that's language you would want to have changed. Thank you.
Okay, and with that, Mr. Reedman, if you want to go into more specific comments from your organization, that'd be great.
Thanks, Mr. Chairman. Mr. Chairman, you talked about why the need. As the good chairman mentioned, about 18 months ago or so, the Supreme Court determined that the state itself has the power to create and uncreate the boards and districts that it puts in place. Municipalities have that power, and the legislature, the executive branch, all of them have that power. But because you grant our powers at the county level, we're political subdivisions of the state, we can only do what you tell us we can do. And their interpretation was that under each of the titles that you see here, county commissioners had the ability to create, but not to uncreate those entities that they have put into place via a resolution. And so the Judiciary Committee took up this bill. My organization is in support of this bill. We've worked hard with the Judiciary Committee to get it to a good spot, and I'll walk through a variety of different elements. At the very front, I want to be very clear that this bill only deals with boards and districts that the commissioners themselves create via a resolution. I think there's some confusion out there that this bill deals with special districts. It does not deal with special districts. It does not deal with fire districts. It doesn't deal with hospital districts or anything of the sort. It only deals with the entities that I previously mentioned. It does not deal with entities that have elected boards. It only deals with entities that the commissioners themselves have the power to appoint. So I want to make sure that that's clear out of the gate here. I also want to make clear that dissolution does not mean that it's done because the function is no longer relevant in the particular community. The case of Laramie County the Laramie County Fair Board versus Laramie County, the commissioners here, although it was contentious, elected that they wanted to put that board, that fair board, under a department because they felt there were better efficiencies that could be gained by doing that. And that has happened in other places in the state. As another example, I have one county, Weston County, where their solid waste district members in a small resolution created board decided to up and leave and turn everything back over to the commissioners. In that case, there happens to be another solid waste district where they'd like to combine the two into one function, but they would still have this entity that sits out there that they have no power to dissolve. Now, there may be an instance also where the purpose of that group is no longer needed and you just want to dissolve it. So this is sort of broad in its potential approaches for the counties, but I want to also say that I don't think counties are going to be going out and dissolving a bunch of boards and districts that they've created. That's not what this is about. It's simply giving them that power that exists so many other places in statute. Now, I do want to just point to a few elements of the bill. I did mention that the Senate added the language on page 4, the provision C on line 1. This was, again, something that I had, the general concept I had introduced to the Judiciary Committee. They put it in place and it was inadvertently omitted, so we brought it back. We did change it for a couple of reasons. The airport districts came to me and said, one, they wanted to ensure that the long-term agreements that they've entered into with the FAA would be considered as part of this process. And Representative McGuire can probably speak to this far better than I, but some of those are almost perpetual agreements with the FAA. So you want to make sure that that's considered. And so we presented this language to them, and they were, the Airport District Association was happy with it. I was also presented by another group that said, hey, we've got regulatory agreements with the DEQ. Those need to be considered. Great. So we added that language in. And then your LSO staff said, well, maybe we should put in the and other obligations. So that's what ultimately resulted in that language being included in this particular legislation. Mr. Chairman, moving to page 6, there are a couple of things that I would, or I guess one thing that I would mention here. The museums, of which I know some of you have heard from, and I suspect you will likely hear from today, shared a concern that there might be an instance where the commissioners want to dissolve the museum, and what's going to happen with the assets. Are the commissioners just going to put that on the front steps of the courthouse and sell it? No. So I went back and I crafted some language, and I was very deliberate in the language that I selected here. I made it a shall. I also made it preservation, because I think shall is a responsibility that you have to follow through. Preservation means that it lives into perpetuity. So we added, we asked the Senate to add on line 20, and shall ensure the preservation of museum artifacts and collections. The Senate Judiciary Committee added in cooperation with the appropriate authorities. They did that after hearing testimony from the museum districts. And we actually like the broad nature of that language. I understand you may hear a request to make that more specific, to make that the Department of State Parks and Cultural Resources is the entity that we're to do this in cooperation with. I will leave that to you on whether that's the policy decision you want to make. My concern with that approach is that it really focuses us on cooperating with only one entity. And I suspect there may be assets that would be appropriate for us to talk with somebody other than the State Parks and Cultural Resources. It might be the tribes, for example. It might be another authority on a particular asset that is in the possession of that museum district. And I also understand they may ask you to be very prescriptive on when we can do these closures, and I'd ask you to resist that and not get too prescriptive on when that can happen. This isn't about personalities and us trying to shut things down, and I don't want us to get caught into that's the only time we can close it down if we have a difference of personalities. And then, Mr. Chairman, I would just comment that I was approached this week by one of the solid waste and disposal districts, who I think may be confused that this deals with special districts. And they've requested that you add in some language that would draw us into Title 22. I would ask you to resist putting this into Title 22 for two reasons. One, Title 22 is elections. And as I told you earlier, this doesn't deal with boards that are established via election. And second, Title 22, the specific area that's referenced, deals with special districts that do have elections, and these don't. So for those reasons, I would suggest we not go down that road, and appreciate your consideration of the bill as it stands. And with that, Mr. Chairman, I'd be happy to answer any questions.
Questions, for Mr. Reaman? Representative Clausen.
Mr. Reedman, just one, or Mr. Chairman, Mr. Reedman, as a matter of practice before this court case, is this how we did it anyway?
Mr. Chairman, can you repeat the question?
As a matter of practice before this court case, is this how county commissioners did this anyway when they did dissolve boards?
Mr. Chairman, the reality is that there is at least one instance that I'm aware of where a county did dissolve its fair board. I don't know if they followed this exact process that's established here. This is something we came up with the Judiciary Committee, but yes, they had previously dissolved their fair board. It was never taken to court, never challenged, and thus we never had a case on that one.
So it's fair to say, Mr. Reaman, that the statutes now allow creation of these boards, and they allow the commissioners to remove any member, but nowhere in the current law does it allow you to technically dissolve a board. And we can maybe disagreement if that was an oversight or not thought about, but that's why the Supreme Court, first a district court, I think agreed with the county commissioners, and then the Supreme Court said, we can't find necessarily any specific statutory authorities. And that's why the bill's before us today. Does that seem fair?
Yeah, Mr. Chairman, I think that's absolutely fair. I mean, if you go into the museum board statutes, it says that the county commissioners may purchase these assets, they may own them, they may acquire them, they may construct certain pieces, they can establish a board, and it does have a provision for removing them in certain circumstances, but there's nothing that explicitly gives them authority to dissolve them. I think the one perhaps exception to that rule is if you go into the solid waste disposal districts statutes 1811-101A, it allows the commissioners to establish the district by resolution, and then it has a sentence that says areas may be added or subtracted from an existing district in the same manner. One may read that, and I'm not an attorney, but one may be able to read that to say you could completely dissolve that. But I suspect another interpretation would be that you could shrink it to its smallest point, but never completely dissolve it. So yeah, there's nothing explicit in each of these statutory constructs. And I think that's what the Supreme Court was saying. You need to have that in order to completely dissolve them.
Okay, Representative Roscoe, question? Okay, further questions, committee? Anything else, Commissioner Livingston, Wyoming County Commissioner, Commissioner of the Year?
Well, thank you very
If
much.
you guys didn't hear.
I think our executive, Mr. Chairman, I think our executive director presented it quite well, and I have no comments at this time.
Okay, and the one and only venerable Commissioner Malm, anything?
He's also a realtor.
He's also a realtor.
Mr. Chairman, I think Jeremiah did a fine job of explaining it, and I won't go and relive the whole saga that was our Supreme Court case. So, but if you want to ask me about it after, I'm happy to talk to you.
Okay, thank you very much. Other public comment on Senate File 27 in the room. Clerks are good. Insurance is good. Anyone online? We do. Bring them on in.
Mr. Chairman, we have a Mr. Robert Henning.
And I believe committee, Mr. Henning has an amendment. He emailed me, I assume emailed all of you, and then there's an amendment. Welcome, Mr. Henning, to corporations. Floor is yours.
Good afternoon, Chairman, Committee. Thank you. I'm going to try and be brief. I know you have short time over the recess. I represent the Colorado Wyoming Association of Museums. I'm a volunteer board member from Gillette. And today we'd like to talk about the intention of this bill versus what we think will come of it. I did testify before Joint Judiciary last week, And we discovered some confusion about the intention and what the resulting authority will be. While I propose that this bill would allow counties to operate museums without boards, and I believe that's what Mr. Riemann just said, that there's the potential that commissions would remove the board and operate the museums as departments. One senator stated, I think under this proposed statutory change, frankly, that can't exist. So if you have a museum, it has to have a board. This is merely talking about if said museum board is dissolved and then what would happen. I suggested to the committee and maintain that the language of this bill does not make that clear. It's not specific enough. When I proposed this to the senator, he again stated there is no instance that there will be county commissioners running a museum. So that's what I ask of this committee today. What is your understanding of this bill? And should we not make the language more clear so that future misunderstandings don't end up back in the court system? The Colorado-Wyoming Association of Museums is asking the committee today to amend this bill to make it clear that counties may only dissolve museums in two instances: if that museum is going to be closed, or if that museum is going to be absorbed into a special museum district. We ask this because we truly believe museums are stronger and safer with a citizen board running those museums. And I will leave it at that. And if you have any questions, I will stand for those.
Questions for Mr. Henning? And I do believe you provided an amendment to the committee as well. Mr. Henning, should we want to take that up? Committee, I did send you a copy of LSO's research in this regard from the judiciary meeting. And it's 18.9.101 is the statute. And just so, because I know Mr. Henning kind of asked what our understanding was. First, we weren't the interim committee that dealt with this, even if I was on that committee. But the statute says each board of county commissioners may construct, maintain, and operate a public auditorium, athletic field, civic center, or other community buildings, and appoint a board of trustees to control, maintain, and manage fairgrounds, airports, parks, and pleasure grounds, to conduct agricultural, industrial, other fairs, and exhibitions. And so that's the statute we're talking about. The county commissioners can appoint those boards and create those boards. The question is, once they're appointed, can a county commission dissolve that? Certainly the statute now allows them to remove members. This would specifically allow them to dissolve those boards, assumedly as they see fit. And doesn't really put a whole lot of sideboards in my estimation, outside of some notice and a public comment hearing on preventing it, right? The board doesn't have to go in the red, doesn't have to have any number of specific things. So that's my understanding since you asked. I don't know if anyone on the committee has a different understanding, but that's how I would read the statute. Any other questions for Mr. Henning at this time? Not seeing any. Hang tight. If you turn your camera off, we'll keep working the bill. And if we get to that amendment, certainly bring you back in for any commentary.
Thank you, Mr. Chairman.
Other public comment on the bill? Seeing none. No one else online? Okay, we'll close public comment on Senate File 27. Committee, what is your pleasure? Moved by Duncan, seconded by Air. Discussion Committee, Representative Duncan.
Thank you, Mr. Chairman. As I reviewed this, as I studied this, this is my concern with this amendment. That some of the assets could be private, perhaps some, as in the county commissioners mentioned, some could be tribal. So there's all different types of assets in these. They're not necessarily public. So going to the county, to the state parks and cultural resources, that seems too restrictive. And so I think it's best to keep it broad, because there's a lot of museums, and I know there's some in our area that are actually private and they've been established, but everything's been donated by a private citizen and they may want those back, or their family may want those back. And so I just feel like we don't need to be so restrictive, and that's my point.
No, and committee, it is interesting if you have a museum, right? Because when the county commission establishes these, they allow them to use taxpayer dollars assumedly to perhaps purchase or acquire, whatever goes in that museum. But I would imagine some of those museums also get an awful lot of kind of personal donations. And you would hope that the family, when they donate those, have some type of contractual stipulation that should something ever go awry, they return from the family. But I would imagine in some cases that is also not true. So the county, if they dissolve the museum board, may get an interesting asset that they may not know what to do with. And hopefully that public hearing would play a role. And I was contacted by another museum board that asked to take museums out of this altogether. I think I'm sensitive to that, but then I feel like we create a special segment. We're not treating a fair board or an airport or a park different than a museum. And from my work on special districts, every 20 years, we have a big special district task force. We bring everybody in. Over 20 years, we carve out little niches out of all of them. And 20 years later, we bring them all back in. And so I'm just a little hesitant to start carving niches out of statutes. How many? I've only lived through one of those cycles, but I have been with other people who've spent 2 or 3 times on special districts. So I don't actually think the amendment proposed is necessarily a benefit. I like to trust my county commissioners. If they do have a public hearing, they would do what's best for those artifacts and exhibits and try their darndest to make it work on behalf of the constituents and consult with the appropriate. So I do kind of like the amendment language the Senate put in there. So I don't have any amendments to offer, but committee members, if anyone else does, or any further discussion, certainly happy to entertain any thoughts. Representative LeBeau, I mean, I know some of the mention was, what are these are tribal artifacts? I guess just a question.
Sure.
Do you trust the county commissioners to consult with the proper people, or do you want stronger language in that regard?
I really, in my apologies, I'm unsure right now. I don't know if this is, if the Department of State Parks Cultural Resources would be better or would be worse. We have a federal act, Native American Graves Repatriation Act. We have Section 106. So we repatriate artifacts, and if there's no ownership of it, particularly, it's just all complicated. But I'm gonna rely on some tribal expertise. So I may run an amendment just to let the committee know. Possibly. It's not a for sure thing. I just gotta check into it more. And I did have a good conversation with Mr. Riemann about this.
And for future reference, the microphone you're using is tied to the chair next to you online. So just look like a blank chair is talking. Further discussion, committee. Seeing no further discussion. Were you ready for the question? Question being called on Senate File 27. Barb, as soon as you walk away from your desk, then I ask you to call the roll. If you'd call the roll on Senate File 27.
Representative Blackburn.
Excuse me.
Representative Burt.
Aye.
Representative Clausen. Representative Duncan. Vice Chairman Air.
Aye.
Representative LeBeau. Representative McGuire. Representative Roscoe. Chairman Zwanitzer.
Aye.
8 ayes, 1 excused.
And so committee, since I was on judiciary in the interim, I'm happy to take this bill. I know Chairman Olson was a little confused on why we got this, but I assume it was because the speaker was here last week for a similar bill and shipped it our way. So I'll bring that on the floor. We're supposed to be back on the floor in 10 minutes. I don't know if the county commissioners think we can get through Senate File 49. They're already on their way out. So committee, let's hold on to 49 and 74 until our Monday meeting. I believe we only got one other bill this morning of the Senate file, so we'll probably put that on. We have another one on insurance amendments, another joint interim committee bill. So those 3 should be up Monday. I'll see you back in the chamber in 9 minutes. We are adjourned.